At the height of the 20th century, and quite often much earlier and much later than that, in the great houses of New York and Newport and Palm Beach, and in the not quite so great houses of the professional and merchant class that had risen with them, a particular figure moved almost silently through the rooms, laying out linen, refilling the decanter, tightening the cover on the bed, closing the shutters against the afternoon sun. In the mythology of the American Gilded Age, and in the somewhat later mythology of the British stately home that the American imagination borrowed, this figure, the butler, the lady's maid, the valet, the housekeeper, the nurse, is always in the background. The action happens in the drawing rooms of the standard novel elsewhere. This is a documentary about a very small number of occasions on which the action stopped happening elsewhere and started happening in the servants' hall. It is a documentary about three specific cases spread out over roughly 100 years of American domestic life, in which the servant of an extraordinarily wealthy employer, a butler, a cook, a private duty nurse, ended up in the will of the person they had been hired to serve as the principal beneficiary. In one of the cases, the servant briefly became one of the wealthiest self-made individuals in the country and then died 3 years later in the mansion he had bought with the money. In another, the servant inherited an apartment on Manhattan's Upper East Side full of paintings by an important Russian émigré artist, and organized a Buddhist rite for his former employers in a small crematorium in Queens. In the third, the servant received, over the 20 years of her employment, and afterward, roughly $31 million in gifts of houses, cars, jewelry, dolls, and a 19th century Stradivarius violin. In each of the three cases, the extended family of the deceased employer contested the will. In each of the three cases, the extended family succeeded in recovering some portion of what they considered their birthright. In none of the three cases did the extended family entirely dislodge the servant or entirely reverse the will. In all three, the courts of the state of the deceased's residence, after review of the specific evidence, we accepted, in some substantial degree, the choices that the deceased had made about who should receive the accumulated property of a life. Subscribe for more documentaries on the great dynasties of old money. New episodes every week. 3 cases, 1 old profession, and a great deal of embarrassed silence at the end on both sides of the estate lawyer's desk. The story of Bernard Lafferty begins in the small village of Creeslough in the northwest of County Donegal on the 14th of April, 1945, 3 weeks before the end of the Second World War in Europe. He was one of 6 children born to a small farming family, and by the age of 17, both of his parents had died. He had left school at 14. He had begun to work, first as a farmhand, and then in the way of a certain generation of Irish rural young men who found that the domestic industry of the northeastern United States would take almost anyone, as a waiter in a Philadelphia hotel. He arrived in America in the middle of the 1960s. He was very tall, very thin, and according to those who knew him at the time, unusually good at reading a room. He was also, according to his own quiet account of the following years, quite lonely. He drank. He had, on and off through his 20s and 30s, periods of considerable struggle with alcohol. What saved him, in his own telling, was a very particular kind of professional discipline. He observed. He read hotel etiquette manuals. He listened to the private conversations of the guests he served and understood, before most of the other waiters in the room, when a wine glass needed refilling and when it did not. In the middle of the 1970s, he was hired as a personal steward by the American singer Peggy Lee. He remained with her, on and off, for the better part of a decade. He met, in the course of his employment with Peggy Lee, other members of the small, distinguished, and generally rather private world of the American celebrity household. He worked briefly and by a Hollywood arrangement whose details have never been made entirely public for Elizabeth Taylor. He knew Sophia Loren. He was, by the middle of the 1980s, one of the most quietly recommended household stewards on the west coast of the United States. In 1987, at the age of 42, he was recommended to a considerably wealthier employer than either Peggy Lee or Elizabeth Taylor. Her name was Doris Duke. Doris Duke was, on the morning she agreed to hire him, 74 years old. She was the only child of James Buchanan Duke, the North Carolinian tobacco merchant who had co-founded in the 1890s the American Tobacco Company, and who had established, in his own last decade, both Duke Energy and the benefaction that would rename a small Methodist college in Durham as Duke University. When her father died in 1925, Doris was 12 years old. She had inherited, on the ordinary reckoning of the interwar American press, roughly $100 million, an inheritance the New York tabloids described, in the phrase that would follow her for the remaining 68 years of her life, as making her the richest little girl in the world. She had married twice, unhappily. She had lost, in 1940, a daughter who died within 24 hours of birth. She had spent, from that year onward, a great deal of her time traveling to Hawaii, where she had built the Islamic-inspired estate she called Shangri-La, to Newport, where she owned the mansion known as Rough Point, to Somerville, New Jersey, where the family estate at Duke Farms occupied more than 2,000 acres of garden parkland. She was 74 when Bernard Lafferty first walked into her Duke Farms drawing room in the spring of 1987. He was, by every account of the interview, extraordinarily deferential and extraordinarily competent. She hired him almost immediately. For the next 6 years, he was her butler. What that word covered in the practical operation of a Duke household in the late 1980s was considerably wider than what a Belgravia butler of the 1880s would have recognized. Bernard Lafferty traveled with her. He supervised her staff at each of the 4 residences. He held the keys to the safes. He organized the receptions she gave for the visitors who came, in her final years, to see her. A small, aging circle that included, according to the accounts of those who visited during the period, the singer Peggy Lee, whom Lafferty had previously served, and a scattering of the older Duke family friends and household advisors from the New York and California decades of her life. He read the correspondence. He made, in the way that a very trusted senior member of a household staff is quietly required to make, the small daily decisions that Duke herself no longer wished to make. And he was there for the last 3 years of her life when she was not. His own quarters throughout that 6-year period were slightly unusual for a butler of his generation. At each of Duke's 4 principal residences, Duke Farms in New Jersey, Rough Point in Newport, Shangri-La on the coast of Oahu, and Falcon Lair above Beverly Hills, a set of rooms was maintained for him, prepared in advance of Duke's arrival, and left available to him whether Duke was in residence or not. He traveled between the 4 addresses on Duke's schedule, and in the last 2 years of her life, on a number of occasions when Duke herself was too unwell to travel and required a member of the household staff to visit one of the closed residences on her behalf. What he did on those visits, beyond checking, in the ordinary way, on the condition of the buildings and the small resident staff, has not been recorded in any of the papers that were later filed in the estate proceedings. Duke suffered the first of a series of strokes in the spring of 1993. She was, from that moment onward, no longer able to run her own affairs with the completeness of purpose that had characterized her earlier decades. In April of that year, in the presence of her lawyer, she revoked the executor arrangement of her earlier will, which had named an old family friend and physician, and appointed in his place Bernard Lafferty. In the same document, she gave Lafferty the authority to appoint, at his sole discretion, the remaining trustees of what would become the Doris Duke Charitable Foundation, the private charity to which the bulk of her $1.2 billion estate was to pass on her death. She died 6 months later, on the 28th of October, 1993, at her Beverly Hills home, Falcon Lair, the former residence of Rudolph Valentino. She was 80 years old. Her body was cremated. Her ashes were in accordance with instructions she had given to Bernard Lafferty in the last year of her life, watered from a boat off the coast of Hawaii in the waters visible from the terrace of Shangri-La. The following morning, Bernard Lafferty, the son of a small farmer from Creaslough, was, in the operative language of the Surrogates Court of the State of New York, the sole individual executor of an estate valued at over $1 billion. He did not, in the strict legal sense, inherit it. That distinction over the following 2 years would matter a great deal to a very large number of lawyers. The estate itself was to pass, once probate cleared, to the Doris Duke Charitable Foundation, a private philanthropic body of which Lafferty would be the founding lead trustee. His personal legacies were more modest on the scale of the estate as a whole. He was to receive, under the will, an executor's fee of up to $5 million, an annual salary of $500,000 for as long as he lived, and a lifetime residence in one of the Duke properties of his choosing. He would in effect control the disbursement of $1 billion to the American arts, environment, medical research, and animal welfare communities. He would also, in the personal sense of what a wealthy man's life looked like, be transformed overnight. The transformation was, as one might expect, poorly received. Within 18 months of Doris Duke's death, 6 separate parties had filed legal challenges to the will. There was Chandi Hefner, a former adherent of the Hare Krishna movement, whom Duke had legally adopted in 1988 at the age of 35, and had then, in 1991, formally disowned. There was the previous executor, the physician Harry Demopoulos, who argued that Duke had been unduly influenced during her final months. There were 3 former Duke servants who had themselves been left small legacies. And there was a woman named Tammy Payette, who had served as one of Duke's deathbed nurses, and who, in a sworn affidavit produced in January of 1995, claimed that Doris Duke had not died of natural causes, but had been given, in the last hours of her life, a fatal combination of morphine and Demerol. The Los Angeles County District Attorney's Office would in due course, in July of 1996, conclude that there was no credible evidence to support this claim. Ms. Payette herself would in due course be convicted, on unrelated matters, of stealing from her patients and would serve a prison sentence. But by then, the will contest had cost the Duke estate, by conservative estimate, more than $50 million in legal fees. Not a single dollar had, at that point, been disbursed to any charity. The surrogate of New York, presented with the accumulating litigation, summarily removed Bernard Lafferty and the corporate co-executor United States Trust from their positions in early 1995. Both appealed. In January of 1996, the New York Court of Appeals, the highest court in the state, reversed the summary removal, holding that the surrogate had abused her discretion by acting without a proper evidentiary hearing. The case is still cited today in the American probate literature, but the practical outcome, 5 months later, was a global settlement of all outstanding claims. Chandi Hefner would receive $65 million. Lafferty would relinquish his role as sole executor, keeping his $500,000 annual annuity and his $4.5 million executor's fee. He would step away from the day-to-day management of the Doris Duke Charitable Foundation, though he would retain a seat on its board. He bought, with a portion of his fees, a mansion in the Bel Air estates of Los Angeles, some 10 minutes drive up Benedict Canyon from Falcon Lair, where Doris Duke had died. It cost him $2 million. It had, according to the Los Angeles Times report of the following November, a bedroom with a 20-foot ceiling, blood-red velvet curtains, and a Venetian chandelier. He furnished it in the ordinary sense of the word, but by all reports from those who visited him during the 3 years he lived there, sparsely. He did not entertain in the manner of the Duke establishments of the previous decade. He was not, in the last months of his life, according to those who continued to visit him, a well man. His blood pressure had been high for years. He drank on and off, more than his physician had recommended. Guests staying with him in the Bel Air house, the same friends who would in due course discover his body on the morning of the 4th of November, described him, in the interviews they gave the Los Angeles Times in the days following his death, as tired. On the morning of the 4th of November, 1996, 3 years and a week after Doris Duke's death, house guests staying at the Bel Air estate found Bernard Lafferty in his bed. He had died in his sleep, sometime in the small hours. He was 51 years old. A Los Angeles County coroner spokesman told the press on the same morning that there was no sign of any foul play. His spokeswoman told the same reporters that he had suffered for some years from very high blood pressure. An autopsy was requested. In the language of the coroner's report that followed a few weeks later, his death was ruled to have been the result of a heart attack. Under the terms of his own will, prepared in the 2 years before his death, Bernard Lafferty's ashes were cremated and, in accordance with his own written instruction, taken to Hawaii, and scattered from a small boat in the same stretch of water off Shangri-La, in which the ashes of Doris Duke had been scattered 3 years earlier. He had, at his death, no surviving immediate family and no children of his own. What the residue of the money he had received from the Duke estate went to, on his death, is not a matter that ever attracted the same volume of press coverage as the will contest that had followed his own inheritance. It is, on any reasonable reading, a matter that concerned only his lawyer. Some servants, in the end, keep even their employer's grave. To understand the extreme rarity and the extreme legal complication of a servant inheriting from an employer, one has to understand what a servant was in the American Gilded Age and in the interwar decades that followed it. And to understand what a servant was, one has to begin, quite prosaically, with the numbers. At the height of the 1890s, a large New York millionaire household, one of the Fifth Avenue establishments modeled by their proprietors on the great London houses of Belgravia and Grosvenor Square, routinely employed between 15 and 25 servants for a family of, say, 4. The Newport summer cottages of the same families during the July season could employ 40. In 1899, the American housekeeping author Mary Elizabeth Carter, herself a former household manager in one of the smaller Astor establishments, produced a book called Millionaire Households in Their Domestic Economy, in which she laid out, department by department, the roles of the staff that a self-respecting, new money family should aim to maintain. At the top of the female side of the establishment was the superintending housekeeper on a monthly salary between $50 and $150. Beneath her stood the lady's maid at $25 to $40 a month, whose duties involved the personal wardrobe and toilet of the mistress. Beneath the lady's maid came the housemaids, the parlor maids, the kitchen maids, and at the very bottom of the female side of the hierarchy, the scullery maids, who at $15 a month did the roughest work of the kitchen, the peeling of vegetables, the scrubbing of pots, the disposal of ash from the stoves. On the male side, the equivalent to the housekeeper was the butler, who, in Carter's careful phrase, must be a man of some breeding and considerable observation. Beneath him were the footmen, the coachmen, the grooms, and, in the household of a serious gentleman with a serious wardrobe, the valet, a position that, at its best, was the male equivalent of the lady's maid, but that carried, in the specifically American establishments of the period, a slightly more European flavor, because the very best valets were almost invariably English or French. The essential fact about all of these positions, in the specifically American context, was that they were understood on both sides, by servant and by employer, as strictly temporary. Nobody on the American reading was supposed to spend an entire working life in one household. The English system, in which a butler might enter a great house at the age of 15 as a hall boy and leave it 60 years later as the senior member of the staff at a state funeral, did not apply here. Domestic service in the United States was very largely an immigrant profession, and it was one that immigrants and their children exited as fast as they could in favor of the professions, the small business, the salaried office job. The Dry House Museum in Chicago, in its careful essay on the subject of American domestic service, notes that the average length of tenure of an American servant in a single wealthy household in the 1890s was less than 2 years. The physical conditions of the work were, at the same time, largely invisible to the family being served. Servant quarters in the great Fifth Avenue houses were almost invariably on the top floor, immediately under the roof, the sootiest, hottest, and coldest part of the building, depending on the season. The rooms were small, unheated except by a single common flue, and generally shared. A parlor maid at a Vanderbilt establishment in the mid-1890s would rise at 5:30 in the morning, dress in a small, unlit room shared with 3 other women, and be in the drawing rooms below by 6, laying the fires. She would go to bed, if the family was not entertaining, at 10 in the evening. She would have one afternoon a week, generally Thursday, off duty. She would be paid at the average rate of $15 a month, plus board and lodging. She would be dismissed, in a great many cases, on the day she informed the housekeeper that she was engaged to be married. For a servant who did complete 20 or 30 years in a single American establishment, the exception rather than the rule, but the ordinary custom of the house, when the employer came to draw up a will, was to acknowledge the long service with a small pension. The bequest was almost always modest, $100 for every year of service, sometimes a small annuity, sometimes a paid-up funeral. Ordinary practice on both sides understood the transaction as a settlement of accumulated goodwill, not as an inheritance. In the surviving American wills of the 1890s, one occasionally finds a specific piece of furniture, a chair, a small clock, a wardrobe, left to a specific servant, generally with a short and rather touching sentence attached, for her long and faithful service. Nobody, in the American probate practice of that decade, left the house itself to the butler. That, in the strict social sense, was not something a person with a family did. This is why the cases in which a servant did inherit, really inherit, not just receive the customary parting gratuity of a few weeks or months' wages, were, in the newspapers of the day, treated as extraordinary curiosities. The most famous American will contest of the entire 19th century, the Howland case of 1868, in which the Massachusetts heiress Hetty Robinson challenged the will of her aunt, Sylvia Ann Howland, turned in part on the testimony of a small group of Sylvia's household staff who had themselves been left modest legacies in the disputed will. In the memoranda of the Robinson lawyers, they are referred to dismissively as the nurse witnesses legatees. The suggestion, implicit in the phrase, was that a servant who inherited was, almost by definition, a servant who had exercised undue influence. That suggestion, and the legal presumption that went with it, would haunt every subsequent case of the same shape for the following century and a half. There were all the same occasional cases. In the Philadelphia press of the early 20th century, one finds, buried among the more sensational obituaries of interwar millionaires, small columns reporting that a housekeeper who had served an elderly widower for 20 or 30 years had been surprised, on the reading of the will, to find that she had inherited most of what he had left. In February of 1927, for example, the Philadelphia Inquirer reported the case of a 50-year-old German immigrant woman named Anna Kubach, who had worked for the retired shipbuilder Matthias Settinger for the better part of 30 years, and to whom Settinger, who was 89 at his death, and who had, on paper, surviving family, had left an estate of approximately $200,000. In today's money, the estate would have been worth a little over $3.5 million. The family contested. The courts, in the end, upheld the will. Anna Kubach kept the money. In the small photograph the Philadelphia Inquirer ran of her, taken on the day the story broke, at the front door of Settinger's row house, she looks, according to the caption, bewildered but composed. Cases of this shape were, in the practical scale of the American economy of the first half of the 20th century, very rare. The typical bequest to a servant, in the will of a wealthy American of the period, was of the order of $100 for every year of service, sometimes with a separate, small provision for the widow or the children, and in the cases of a truly beloved retainer, perhaps a paid-up small annuity for the remainder of the servant's own life. Nothing more. The English tradition, the tradition preserved later in the memoirs of Rosina Harrison, the lady's maid who served the American-born Viscountess Astor of Cliveden for the better part of 30 years, and whose 1975 book, My Life in Service, would be one of the last great documents of the vanishing British domestic profession, did not produce, on the American side of the Atlantic, its own extensive canon of below-stairs literature. The American servant, when she or he retired, tended to disappear from the historical record altogether. Which is why, when in the late 1980s and again in the second decade of the 21st century, the same shape of case appeared once more in the American press, an aging person of enormous wealth, an intimate household attendant of no particular fortune, a will contest, and a fortune shifting hands in ways the deceased's blood relatives found it very difficult to accept. The country very quickly discovered that it had, in its cultural memory, no ordinary language with which to discuss what had happened. The two cases we now turn to happened in the second of these periods. The second story begins in a Kathmandu hotel. Indra Tamang was born in a small mud and thatch house in the hill country of central Nepal, sometime in the middle of the 1950s. His family were subsistence farmers. He was the youngest of several children. He had, by his own account of his childhood in the later interviews he gave, no formal education past the age of 9, and no particular skills other than what a Nepalese village boy of that generation would have picked up in the ordinary course of his upbringing: some knowledge of livestock, a facility for cooking rice, an acquaintance with the small manual crafts of the household. In his early teens, in the way of a certain generation of young Nepalese men whose village economies could no longer support them, he came down out of the hills and found work in Kathmandu. He was hired in the late 1960s at a hotel in central Kathmandu called the Yak and Yeti, a somewhat legendary establishment, then in its early years, that had been founded by a former Russian Olympic skier named Boris Lasanovich, and that was serving as, in effect, the diplomatic drawing room of Nepal for the American, European, and Eastern Bloc visitors who had begun to arrive in the country in the years after King Mahendra had opened it to tourism. Indra worked in the kitchen. He was, by the accounts of those who knew him at the time, quick, quiet, and immediately liked. In 1969, an American guest at the Yak and Yeti asked whether he would be willing to come back to the United States as a personal household attendant. The guest was Charles Henry Ford. He was 61 years old. He was an American poet and photographer of the Surrealist movement, born in Mississippi in 1908, and he had spent most of his working life in New York and in Paris. He had been the founding editor in 1940 of the little magazine View, which had introduced the American public to a great deal of the European surrealist writing of the wartime decade. He had lived from the early 1930s until the death of his partner in the winter of 1957 with the Russian émigré painter Pavel Chilichu. He was, by 1969, a widower in the informal sense of the word, and he was traveling at a slow, deliberate pace through the Himalayan foothills that he had begun to write about in the poems of his late middle age. He met Indra in the kitchen of the Yak and Yeti. He offered him a job. Indra, who had never been more than 50 miles from his birthplace, said yes. He arrived in New York in the early 1970s. He would live there uninterruptedly for the following 40 years. He came in through JFK on a passport that had been arranged over the course of several months of paperwork by Charles Henry Ford's American lawyers. He arrived with a small brown suitcase, a change of clothes, and according to the story he later told a Wall Street Journal reporter, a package of rice that his mother had given him at the door of the Kathmandu bus depot on the morning he left. He did not speak more than a few words of English. He had never seen a subway. And he had at that point no clear idea of who Charles Henry Ford actually was, other than the American gentleman who had eaten in the Yak and Yeti dining room 3 or 4 times a week for the previous 8 months, and who had, in that time, taken the trouble to sit and talk with the kitchen staff after each of those dinners in a way that no other Yak and Yeti guest of that season had done. Charles Henry Ford lived at the Dakota, the enormous French Renaissance apartment building on the northwest corner of Central Park at 72nd Street in Central Park West, whose residents at the time included John Lennon and Yoko Ono, the actress Lauren Bacall, the composer Leonard Bernstein, and a large number of the older established figures of the New York arts community. Ford's own apartment was on the 7th floor. It was full of paintings by Pavel Chilichu, which Charles had inherited on his partner's death in 1957, and which included some of the most important surviving works of Chilichu's late period, a body of work that art historians in the following decades would come to consider one of the finest private holdings of pre-war European surrealism still in American hands. Indra was hired, formally, as a cook. In practice, over the following 3 decades, he became the person who ran the household. The building in those first years of Indra's employment was one of the great crossroads of American cultural life. Charles Henry Ford entertained often. His guests over the course of the 3 decades in which Indra ran the household included figures from the literary, artistic, and photographic communities that Charles had known since the surrealist years of 1940 and had continued to know into his 80s. Writers, painters, editors, and gallerists whose visits to the Dakota apartment on any given evening were quite often not recorded on either side in any diary that has since become public. Indra prepared the food, he served it, he cleared the dishes, he listened to conversations he did not always fully follow, and he retained over the following 4 decades the discretion never to describe those conversations in public. He also, in the evenings when Charles was not entertaining, cooked in the Dakota kitchen the small rice and lentil dishes of his own upbringing, dishes that, according to Indra's own later interviews, Charles Henry Ford, in the last decade of his life, came to prefer over almost every other cuisine he had grown up on. He also became, in the informal sense that no employment contract has ever quite managed to capture, a friend. Charles's sister, Ruth Ford, lived in an apartment on a different floor of the same building. She had been a well-known stage actress in the 1940s and 1950s, had appeared in a small number of Hollywood pictures, most notably alongside her husband, the actor Zachary Scott, whom she had married in 1952, and had lost Scott to cancer in 1965. She and Charles were extremely close. As they aged, Charles into his 80s, Ruth into her 70s, they lived in effect as a single household distributed across 2 Dakota apartments, connected by an internal staircase and by the quiet, tireless work of Indra. Charles Henry Ford died at the Dakota on the 27th of September, 2002. He was 94 years old. In his will, he left the 7th floor apartment and the Chalichu paintings to his sister Ruth. Ruth continued to live in the building with Indra as her household attendant. She died on the 12th of August, 2009. She was 98 years old. Under the terms of Ruth Ford's will, which had been drawn up several years before her death and updated at intervals over the last decade of her life, Indra Tamang, aged approximately 55, inherited both Ford apartments at the Dakota, the substantial holding of Pavel Chalichu paintings that had passed through Ruth's ownership, and Charles Henry Ford's own literary papers and photographic archive. There were, in Ruth Ford's own family, no surviving direct descendants. There were more distant relatives, but they were, at the reading of the will, not present. The 3-bedroom apartment on the 7th floor of the Dakota was placed on the market not long afterward at $4.5 million. The paintings, valued by the auction house Christie's, added several million more. The Wall Street Journal broke the story in the early summer of 2010 under the headline, "The Butler Did It." The piece was picked up over the following 2 weeks by the Seattle Times, the Associated Press, and every wire service in the English-speaking world. Indra, in the interviews he consented to give in the aftermath, was uniformly reticent. He observed in the phrase later reported by the Seattle Times that between Charles and Ruth and himself, there had been a friendship. He was not, he emphasized, in a strict sense, only a butler. Their bond, he said, had been more than that. He also observed, with what interviewers described as a quiet good humor, that the public perception that he had suddenly become extremely wealthy was, in the practical sense of what he had received, not entirely accurate. The Dakota apartment would have to be sold to pay inheritance taxes. The paintings would have to be professionally cataloged and, in most cases, disposed of at auction, a process that would consume several years and a substantial fraction of their eventual sale value in legal and auction house fees. He would end the process, he thought, comfortable but not wealthy in the way the Wall Street Journal had suggested. "I don't have more money now than I did before," he told the Seattle Times reporter, and then, in the next line, added, laughing that at least he did not have to worry, quite as much as he had worried before, about how he would pay his mortgage. He organized, in accordance with what he said had been Charles Henry Ford's own late religious preferences, a small Buddhist funeral rite for Charles in a Queens crematorium in the autumn of 2002. He organized, 7 years later, a similar Buddhist rite for Ruth, following her Episcopal funeral. He returned on visits to the village in Nepal where he had been born. He did not, in the years after the inheritance, live differently. He continued to maintain the Dakota apartments for as long as they remained his. He kept the painting for as long as he kept them on the same walls where Charles and Pavel had hung them 4 decades earlier. Some inheritances, in the end, are received in the way they were given, quietly, and without any evident change of taste. The third story is the most recent, and it is also the story in which the customary tone of the observing documentary maker becomes most cautious. It concerns a person who is, at the time of this recording, still living, and who is entitled to the privacy that any reasonable person is entitled to. The facts of the case, however, are public. They are recorded in the surrogate's court files of Manhattan, in the reporting of Bill Dedman for NBC News, and in the book that Dedman and Paul Clark Newell Jr. published in 2013 under the title Empty Mansions. What follows is drawn entirely from those public sources. Huguette Marcel Clark was born in Paris on the 9th of June, 1906. She was the younger of the two surviving daughters of William Andrews Clark, the Copper King of Montana, United States Senator, and at the time of his death in 1925, one of the 4 or 5 wealthiest men in the country. Her mother, Anna, was Clark's second wife, 40 years his junior, a former harp student he had met in Paris at the turn of the century. Huguette grew up in a Fifth Avenue mansion of 121 rooms. At the time of its construction, in 1911, the most expensive private residence ever built in New York City. She was married briefly, in her 20s, to a New York banker named William McDonald Gower, in a union that was dissolved after less than 2 years and produced no children. She never remarried. Over the following 70 years, Huguette Clark did something very difficult to summarize. She retreated. She spent, during and after the Second World War, less and less time in society and more time in her own apartments and in the very substantial collection of 19th century French dolls that she had been accumulating since childhood. By the middle of the 1980s, she was almost never seen in public. She did not travel. She did not visit either of her other large residences, the mansion known as Belos Guardo, on a 23-acre bluff above the Pacific in Santa Barbara, or the country estate she owned in Connecticut. She lived, on paper, in the Fifth Avenue apartment building, where the family had moved after the demolition of the original mansion. In practice, from the late 1980s onward, she lived somewhere else. In 1991, at the age of 84, Huguette Clark checked herself into Beth Israel Medical Center on Manhattan's East Side for what her physicians afterward described as a minor skin condition. The treatment lasted a few weeks. When it concluded, she did not check out. She remained at Beth Israel, first for a few weeks more, then for months, then for years, in one of the private hospital rooms of the 9th floor. She was in reasonable general health. She was mentally alert. She read, she watched television. She took telephone calls from the small number of intimates she had retained. She purchased dolls at auction through her legal representatives. She simply preferred, she said, to be in a hospital. In due course, and after arrangements had been made with the hospital's administration involving very substantial gifts to Beth Israel's endowment, she was permitted to remain. She lived at Beth Israel for the following 20 years. She was, according to the descriptions of the staff who attended her over that time, descriptions that would in due course be preserved in the affidavits filed at Huguette Clark's death in 2011, an unfailingly polite, softly spoken, courteous, and increasingly frail woman who dressed each morning in a plain hospital gown, ate small meals brought to her at the standard hospital hours, watched a great deal of daytime television, and continued into her 100th year to conduct a very substantial international correspondence about the acquisition of 19th century French dolls. She purchased them by telephone, through her legal representatives, at auction. She never went to see them. She had them delivered to a Fifth Avenue apartment across town that she owned but did not live in, where they were unpacked, arranged, and photographed for her readers, after which the photographs were brought to her hospital room, and she looked at them, sometimes for hours, before instructing that the dolls be repacked and stored. The apartment, in the last years of her life, contained several hundred dolls in glass cases and had not been entered by its legal owner for over 2 decades. Her private duty day shift nurse, from a few weeks after her admission until the day of her death, was Hadassah Perry. Ms. Perry had been assigned to Huguette Clark's floor in the standard way by a home health care agency in the early spring of 1991. She was, at that time, in her mid-30s. She had been born in the Philippines, had trained as a registered nurse there, and had emigrated to the United States some years earlier with her husband. She was, by every account of her subsequent career, an exceptionally diligent professional. She worked, during her employment for Huguette Clark, 12-hour shifts, 5 to 6 days a week at a base annual salary of, according to court documents later filed in the surrogate's proceedings, $131,040 a year. She also, over the course of those 20 years, received, in the form of gifts from Huguette Clark to herself and to members of her family, a series of transfers whose aggregate amount, according to the accounting later placed before the New York surrogate, came to approximately $31 million. The gifts included the money to purchase 5 houses for Miss Perry, for her husband, and for their adult children. They included jewelry. They included a substantial part of the doll collection. And they included, in one particularly widely reported gift, an 18th century Stradivarius violin, although not, according to the reporting of NBC News, Huguette Clark's very best Stradivarius, which was reserved for a different beneficiary. Huguette Clark, at the age of 98, signed 2 separate wills, 6 weeks apart, in the spring of 2005. The first will, dated the 21st of March of that year, left the bulk of her estate to her surviving distant relatives, the descendants of her father from his first marriage, and a $5 million bequest to Ms. Perry. The second will, dated the 7th of April of the same year, revoked the first. It left nothing to the family on the stated ground that Huguette had had minimal contact with any of them over the years. It left the bulk of the estate to a new charitable foundation, the Bellos-Guardo Foundation, that was to inherit the California mansion and open it as a private arts institution. And it left an additional $30 million to Hadassah Perry, over and above the gifts she had already received while Clark was living. Huguette Clark died at Beth Israel Medical Center in the hospital room she had occupied for 20 years. On the 24th of May, 2011, she was 104 years old. The will contest that followed was one of the most exhaustively documented estate disputes of the early 21st century. 19 of Clark's surviving grandnieces and grandnephews, some of whom had never met her, filed a challenge on the ground of undue influence. The New York surrogate initially removed the nominated executors, Clark's lawyer and her accountant, pending a full hearing. Bill Dedman of NBC News, and later of the Empty Mansions book he co-authored with Paul Clark Newell, Jr., would in due course publish the fullest reconstruction of the daily life of Huguette Clark's last 2 decades that has ever been assembled. He would establish from the affidavits and the surviving correspondence and the hospital records that Huguette Clark, until the very last months of her life, retained the full mental capacity to understand the arrangements she had chosen to make. He would also establish that those arrangements, as they had accumulated over 20 years, had transferred an extraordinary quantity of wealth into the hands of a very small number of specific individuals: her 2 lawyers, her accountant, the hospital that had housed her, and, above all, the 2 nurses who had staffed her 9th floor room in 12-hour shifts around the clock. In the settlement that was eventually reached in September of 2013 and approved by the surrogate the same month, the extended Clark family received a payment of $34.5 million from the estate. The estate's lawyer and accountant received nothing under the will, though they were permitted to retain the smaller gifts they had received during Clark's lifetime. Hadassah Perry received nothing further under the will. She was, however, permitted to retain the entirety of the $31 million in gifts she had received during Clark's lifetime, though she was required, as part of the settlement, to return a specific $5 million cash gift that had been made shortly before Clark's death. The Bellos-Guardo Foundation received the California mansion in a substantial cash endowment, and the property today operates as a private arts foundation dedicated to the visual and performing arts. It opens on a small number of pre-booked days each year for public visits. On those visits, a very small number of tourists moved through the 23-acre grounds in single file, past the shuttered windows of the main house, and are shown on a supervised route, the ballroom in which Huguette Clark's mother once entertained the Fifth Avenue social circle of 100 years earlier, and in which Huguette herself, according to the surviving family accounts, had last set foot in the summer of 1953. Miss Perry did not, before or after the settlement, give an on-the-record interview. Speaking through her attorney at the time of the will contest, she observed that she had seen Madame Clark almost every day for 20 years, that she had been not only Madame Clark's private duty nurse, but also her close friend, and that whatever gifts Madame Clark had chosen to make to her had been made freely and out of a genuine friendship. Beyond that, she declined to comment. She has continued at the time of this recording to decline. It is not our place in the ordinary business of a documentary to offer any characterization of that decision. It is, on any reasonable reading, an entirely proper one. Return for a moment to the figure with which we began. The servant in the mythology of American wealth of the last 150 years is almost always understood as a person who has been placed by the accident of the immigrant background, or by the accident of a truncated education, or by the accident of an unlucky birth, in a position of complete asymmetry with the person they serve. The mistress possesses the fortune, the maid possesses the polishing cloth, the gentleman possesses the yacht, the valet possesses the button hook. In the great English novels of the 19th century, and in the American novels that inherited their conventions, the possibility of that asymmetry being disturbed is understood quite explicitly as one of the standing dangers of a life of great wealth. Rich people in these novels are constantly warned about the risk of being manipulated by an unscrupulous servant. Servants in these novels are constantly warned about the risk of being dismissed at the whim of a temperamental employer. The relationship on both sides is understood as one of durable inequality. The three stories we have just heard depart from that convention, in each of the three cases, in a very particular way. In none of them did the servant actively seek the inheritance. In each, so far as the surviving public record shows, the initiative for the transfer of assets came from the employer, an elderly, often lonely, often childless person of great fortune, who had reached a stage of life at which the person nearest to them in the ordinary daily transactions of their remaining years was, quite simply, not a member of their blood family. In each of the three cases, the servant had been in the household for a very long time. 6 years in the case of Bernard Lafferty, 40 years in the case of Indra Tamang, 20 years in the case of Hadassah Perry. In each, the servant was, by every account of those who observed the household from outside, unfailingly attentive, unfailingly present, and unfailingly discreet. And in each, the extended family of the deceased employer challenged the will. In each of the three, the challenge resulted in a settlement rather than a full judicial determination. Because in each of the three, the estate was large enough that the litigation costs, if pursued to the end, would have consumed a significant fraction of the assets that both sides were fighting over. The lawyers in each of the three did well. The servant in each of the three did rather less well than the initial press coverage had suggested, but considerably better than any subsistence farmer in County Donegal, or any subsistence farmer in the Nepalese hills, or any registered nurse in Brooklyn had reasonable expectations of doing in the ordinary course of a working life. The moral of the three cases, if there is one, is not the obvious one. The obvious moral, in the tradition of the English detective novel, is that the butler did it, that a person who spent long hours alone with a wealthy elderly employer in the last vulnerable years of that employer's life exercised, whether by intention or by simple accumulated intimacy, a form of influence that the employer's blood relatives were entitled to regard with suspicion. The public commentary on all three cases, when they broke, tended to reach for that reading almost immediately. But the courts, in all three cases, after very careful evidentiary review, and with the assistance of some of the most experienced probate lawyers in the American profession, declined to reach it. The wills were, in each of the three cases, upheld. The settlements were, in each of the three cases, negotiated. The servants kept, in each of the three cases, a substantial fraction of what their employers had chosen to give them. The less obvious moral, and perhaps the truer one, is that the American century, the century in which vast personal fortunes were accumulated in one generation and then very frequently dispersed within one or two more, produced, along with its great families, an underclass of intimate professional attendants whose actual day-to-day proximity to the wealth in question was quite unlike anything the courts of the 1890s would have recognized. When a Doris Duke or a Ruth Ford or a Huguette Clark reached the last decade of her life without children, without a nearby spouse, and without a routine social circle, the person she saw every morning and the person to whom she said good night every evening was the person she had hired to be there. On the strict reading of 19th century social convention, that person was a servant. On the strict reading of the surviving 21st century evidence, the correspondence, the household accounts, the affidavits of the doctors and lawyers who attended these employers in their final years, that person was something else. That person was, by the actual pattern of the shared daily life, a companion. And the American probate law, faced with the question of whether a companion was permitted to inherit, concluded, in three widely reported cases within 20 years of one another, that the companion was. There is a small graveyard on the northern shore of the Hawaiian island of Oahu, unnamed on any map, some distance from Shangri-La, at which the ashes of two very different people, a tobacco heiress born in New York City in 1912 and an Irish farm boy born in Creesloke in 1945, were scattered from a boat 3 years apart. There is a rented room in a small Nepalese hill village to which the son of the household, approximately 65 years old at the time of writing, and one of the private owners of a substantial collection of European surrealist painting, occasionally returns. There is a private duty nursing register in a hospital on Manhattan's East Side, on which the name of one nurse recurs day after day, 5 days a week, 12 hours at a time, for 20 consecutive years, until one Wednesday morning in May of 2011, the patient in the 9th floor room stopped requiring her attention. The nurse, in accordance with a settlement agreement approved by the Surrogates Court of the State of New York in September of 2013, retained the greater part of the gifts made to her by the patient during those 20 years. She has not, at the time of this recording, appeared in public. The single sentence she gave through her attorney at the time of the will contest, that she had seen Madame Clark virtually every day for 20 years, that she had been her private duty nurse, and also her close friend, has remained her only on-the-record statement on the subject. That, one may reasonably suppose, is what she wanted. Some inheritances in the end are the natural payment for a debt of daily presence that no lawyer and no relative and no Fifth Avenue institution was ever in a position to satisfy.